sur l'état d'urgence est maintenant ouverte.
Well, good morning all, and welcome to day 3 of our policy hearings. And we have this morning a national security and public order emergencies topic. Nous avons ce matin un nouveau panel.
We have a new panel this morning on national security. So, we have Kent Roach, who will be moderating this session.
To introduce our speakers and our panelists and get the program going. Go ahead, Kent.
Bon matin.
Good morning. I'm Kent Roach. I'm a professor of law at the University of Toronto.
Moderator of this panel. I've worked with the EPRWASH, ARAR, and Air India commissions on matters relating to policing and intelligence. This panel includes 2 former directors of CSIS and 2 leading national security scholars, who I will shortly ask to introduce themselves and make opening 5-minute statements. I will then ask them to address a series of questions relating to intelligence as collected by security intelligence agencies and the police, the definition of threats to national security, particularly the 2C definition in the CSIS Act, first enacted in 1984. I will then ask them to address whether that definition should be changed, whether further study is required, and finally, we will explore whether the existing or the new definition of threats to national security to Canada should continue to be used as part of the threshold for the declaration of a public order emergency under the Emergency Act. So without further ado, Mr. Elcock, would you please introduce yourself to the Commissioner and make your 5-minute opening statement?
Good morning, Commissioner. My name is Ward Elcock. I am a lawyer by training. I've spent some 10 years as the counsel to the Privy Council Office from 1984 to 1994. In 1989, I also became the Coordinator for Security and Intelligence, which was the original title of what then became the National Security Advisor after 2001, September 11th. I became the Director of CSIS in 1994, and in 2004, I became the Deputy Minister of National Defense, and subsequently, I was the Coordinator for Security and Intelligence, through the Olympics and the G8 and the G20 on behalf of the federal government, which is my background in these subjects. A comment rather than a statement, because I wanted to make sure that I said it. One of the things that I found strange in the lead up to the Commission and through some of the testimony was the focus on the importance or the relevance of the interpretation that CSIS gives to the definition in the CSIS Act, which is also the definition in the Emergencies Act. To my mind, that was odd because, frankly, the relevance of the interpretation that CSIS gives to that definition is, in my view, beyond the normal rules of statutory interpretation, pretty much non-existent. The reality is the service interprets that provision in the context of its role, of its responsibilities, in terms of the limitations imposed on it, and the limitations that are inherent in the management of any intelligence service. And none of those things are relevant to the discussions of Cabinet or to the issue.
Intelligence failure, especially early warning failure, to policing failure, to eventually the invocation of the Emergencies Act, marked by great uncertainty about what the future might hold. The concept of intelligence failure is a much studied but contested term, and you won't hear it spoken by government officials or ministers before this Commission. This is understandable. It is a hard thing to face, and intelligence failure is easily oversimplified and used for the purposes of scapegoating. My nugget of opening advice to the Commissioner is this. I urge the Commissioner to identify the critical points of intelligence failure and consider their impact on the invocation of the Emergencies Act. Such fact-finding is also relevant to recommendations to avoid future intelligence failures that might shape the course of national security decision-making in a crisis. If we can get the intelligence function right, that might allow us to keep the Emergencies Act legislation on its intended high shelf. To go further, I would say it's important to consider the limitations that affected intelligence collection on the so-called Freedom Convoy, especially in regard to open source intelligence. Equally important is the quality, accuracy, and utility of threat assessment reporting produced by diverse entities, including the Ottawa Police Service, the OPP, the RCMP, and ITAC. On the governance front, it is also important to understand the extent to which a largely decentralized national security system was able or not to coordinate and integrate diverse intelligence and information streams. The testimony heard by the Commission, especially from the National Security Intelligence Advisor, strongly suggests this was a real problem. More advice. Consider the phenomenon of mental maps, especially those used by political decision makers as they received intelligence threat reporting. This includes what they thought of the intelligence function in general and their receptivity to intelligence reports. Finally, it seems to me crucial to understand exactly how the available intelligence informed decision-making prior to and with the invocation of the Emergencies Act. Intelligence failures generate serious consequences for government and society. History is littered with them. If the Commission can successfully write what I call the first draft of the history of the Freedom Convoy, including the intelligence piece, got it, Kent, and determine recommendations to improve the performance of the intelligence system writ large, it will have done notable work in the public interest. Thank you.
Thank you very much, Professor Wark. A little bit under time. Batting cleanup, Professor Leah West.
Good morning, Commissioner. I'm Dr. Leah West. I'm an assistant professor at the Norman Paterson School of International Affairs, where I teach national security law, international law, and counterterrorism. I'm a former DOJ lawyer. My client was CSIS, and I'm the co-author, along with Craig Forsyth, of National Security Law. I'd like to begin by acknowledging that the premise of this panel is seemingly that what occurred in Canada in January and February of this year was a national security threat, at least as we understand it in the law. For this reason, we've been asked to consider the definition of threats to the security of Canada, the challenges of security intelligence, and the rise of IMVE. With the greatest of respect, I'm not certain that this underlying presumption is accurate. I do not question the impacts the protests had on citizens in Ottawa, Windsor, Coutts, or elsewhere, nor do I question the economic impact the blockades and the borders in the capital had on this country. But as we typically understand it, did these activities or their impacts constitute a national security threat, namely one of terrorism? If we take a step back and look at what happened, we should ask ourselves whether unlawful and even violent protests typically give rise to what we call a national security threat under the law in this country. Did we label the G8 and G20 protests in Toronto a national security or terrorist threat?
Est-ce qu'on aurait dit la même chose au sujet des manifestations violentes aux États-Unis dans l'été de 2020? Alors, oui.
Police officers attempting to disrupt a protest, terrorism. Moreover, the fact that individuals who hold extremist beliefs would seek to co-opt a political protest to advance their agenda is not a new phenomenon. We do not label entire protest movements terrorist because some amongst the protesters are looking for an opportunity to create violence. Again, I'd point to the history of G8 and G20 protests and even the Summit of the Americas in Quebec City in 2001. Similarly, we have never labeled blockades and other non-violent but illegal means of obstructing critical infrastructure as terrorism. This country has a long history of protests along rail corridors and ports. While certainly these activities threaten trade and Canada's economic interests, they do not fall within Section 2C of the CSIS Act, no matter how broadly one interprets it. It is the combination,
means to national security. In the hearings, it's often been referred to as an inexact science. Mr. Fadden, you've already referred to it as information. Could you start us with a little discussion about elaborating on your views about what intelligence is?
Okay, thank you. So I'm going to be more traditional here and start talking a bit about national security intelligence and security intelligence by just listing a few of the general characteristics which apply. First, generally speaking, national security intelligence of use to politicians is to be policy neutral. It is not to advocate a particular end, either in policy or operational terms. Ideally, it's prepared by people who are not involved with policy or operations. Again, ideally, it draws on all information lawfully available, secret, confidential, and open source. It's important to remember that in this country, when you can collect security intelligence and how is severely prescribed by law. This has an effect sometime on whether or not information is in fact collected. There are three broad categories relating to, I think, the Emergencies Act that are worth thinking about. Security intelligence, which is mostly what I'm talking about, foreign intelligence, which could have a bearing if there are foreign entities involved, and police intelligence, which Professor Roach is going to talk about in a few minutes. While security intelligence relates to threats to the security of Canada as set out in the CSIS Act, I would argue that it should be broader than that. The definition in the CSIS Act relates to what CSIS can do, not what the Government of Canada or any other institution might consider to be a national security threat. There's a difference, I think, as between what an administrative body can do and what CSIS or another collective agency can do. I think that's fairly important. And to make sort of what may seem like an odd comment, partially in response to what I know Professor West believes, there is more to the Constitution in this country than the Charter, which we seem to forget sometimes. We're supposed to have a constitution similar in principle to that of the United Kingdom. We're supposed to promote peace, order, and good government. And in that general context, defense of the realm and public order is an executive government function that I think we need to remember, even if the very narrow descriptions contained in particular statutes are relevant or not.
And you're making me play cleanup. A few points. I would share the view that a greater degree of sharing of information between the federal government and between federal government agencies and provincial agencies and municipal police forces and so on is important. There have been some efforts to do that over the years. They have not progressed as far as they probably should have. They probably ought to continue to progress, and there ought to be more pressure to make them progress, although to some extent I suspect that that is a result of the reality that national security or national security issues are not widely seen as crucial. The issue of whether or not some national coordination body would or would not be useful, my guess is, frankly, that since we haven't managed to achieve a national regulator for securities issues, we're unlikely to get to the point of creating a national coordination coordination agency for security and national security issues anytime soon. I have long, frankly, resisted suggestions, or have frequently resisted suggestions, that there should be reviews of this or that, and in particular national security issues. Frankly, I'm not sure they're all that useful. They're often formulaic. It is unlikely to happen anytime in the near future, since we're in a minority situation and an election is 2 years away. I suspect that's not going to happen anytime soon. And to be uncharitable, my academic colleagues will probably not share this view, but sometimes I think that academics would like to see more reviews because it gives them something to write about, rather than achieving anything in terms of real process. I think one of the things that is clear here, because it's not my view, frankly, that this was necessarily, as I said earlier, that this was necessarily an intelligence failure. I think one of the areas where there really needed to be better cooperation has nothing to do with the federal government. It's really the issue of how the province of Ontario organizes itself and deals with its police forces. That, to me, in some respects, was a much more important issue than whether we have a national coordination function or broader sharing. That seems, in this case, to have been deficient. It would be, but that is a much more discrete issue. Clearly, in this case, the RCMP did not see it as important to share as it might have. I think that is an inevitable consequences, I think I said earlier, of the way in which police forces function. But if I think that it would be important for police forces broadly writ, since in some sense this, at a certain level, it's certainly in its initial stages, was much more a public safety issue than it was a national security issue, or seen as a public safety issue rather than a national security issue. The issue of police sharing and of perhaps funding of better police analysis capabilities in some cases would be more important than trying to build some national structure, which I suspect we won't get anytime soon.
Thank you very much. So for our last half hour, we're going to drill down on two.
And the lessons, the implications, the consequences of the Ottawa protests. Michael, perhaps you could lead us off on that topic.
Sure. Thank you very much, Commissioner, and all the council who are here. I very much appreciate being included. What I wanted to do essentially today was some briefer comments on overall strategies for dealing with mass protest, and really focus my comments on opportunities for integration planning, some of which are as yet underexploited, but where there may be directions for improvement in the future. In an oversweeping type statement, we can say that the lessons of policing mass protests that were learned at the G20 in Toronto in 2010 were in many ways applied in the mass protests in the Ottawa region and across Canada for that matter, but the lessons of G20 were in many ways not applicable to the nature of protests that we saw this time around. Simply stated, very much the lesson of G20 was to have police work on more of a stand back type strategy of containment, where over a period of time protests would run their course, dissipate, and ultimately where an enforcement action may be necessary, it would be on a smaller scale. That type of approach in Ottawa was heavily criticized, as we all know, and we spoke in terms of a new paradigm in protest type, for which many of the lessons of the past do not seem to apply. So in terms of meeting that new challenge, pooling collective knowledge, pooling collective resources is a major issue. And of course, we've covered the ground thoroughly that coordination across policing agencies, coordination between police agencies and their civilian oversight bodies, and political overseers is extraordinarily difficult. So the comments that I'll make, I'll mostly focus on the framework in Ontario for the reason that Ontario was very much a focus in terms of police coordination for this commission, but also very often what we see in Ontario legislation finds its way into police frameworks across the country over time. So the current reality in Ontario is that police interaction and police governance is ultimately governed by the Police Services Act of 1990. The more recent piece of legislation, 2019's COPS, the Comprehensive Ontario Police Services Act, of which the Community Safety Act is a part, is as yet unproclaimed. Some of the institutions that are created by that legislation are in sort of semi-operation at the moment, such as the Inspector General of Policing that we began to learn about the other day in the testimony of Mr. Wetherill. But we're still waiting on the development of regulations prior to that legislation coming into full effect. So in terms of coordination across agencies, and particularly at the level of planning and sharing resources, there are obviously the proactive and reactive dimensions to integration. At the proactive level, it is clear that where police services boards, by the authority of the Police Services Act 1990, as made clear in the Morden report, although this is mostly the subject of other panels, do have the authority to ask questions and even often input or advice, which chiefs are free to take or leave, on matters of operational planning for most issues, but most especially for major events, what Justice Morden calls corporate events, which is to say events that are large enough that the entire police service is implicated in dealing with that particular event. So there is certainly a role for boards working proactively with their chiefs to ask if the possibility, the need to coordinate with other police organizations could be on the table, and perhaps leading that conversation with their chief and linking up through currently the OCPC by the 1990 Police Services Act, and moving forward, that same role, I understand, will be taken over by the Inspector General with the new legislation. My understanding that the IG would serve as a type of quarterback role for police services boards with the Solicitor General, coordinating messages, offering mostly procedural advice rather than policy advice to boards from the Inspector General. Where there's an anticipation that there might be the need for a major event of resources and coordination.
You just slow down a bit for
Sure.
the interpreters. It's
Certainly.
a bit of a challenge.
Certainly. Where there is
a little bit later on here as I continue my conversation. My expertise in police and community engagement and police liaison is a lot more granular, I think, than the presentations and the expertise at the table. But I hope to bring some operational perspective and experience to sometimes what is a very theoretical discussion in dynamic situations. Mass demonstrations in assembly are very dynamic, and as you've heard, they're changing in real time. There's no realistic way to prescribe and plan for every possibility. People in protest or mass assembly situations are increasingly less predictable. Experience suggests this is intentional. Disruption is often sought. The larger the impact, the more your underlying interest may be served. The CACP training and PLT trained officers are impartial, but not neutral. Impartial to address bias that may exist. It really should not matter what a police officer's personal views are. But not neutral means once safety is compromised, we are obligated to act. The primary role of the police in any demonstration or assembly is to preserve the peace, protect life and property, and enforce the law. Police to accommodate rights is our job, but it's also to maintain peaceful, lawful, and safe assembly. PLT, Police Liaison Team, is relationship building, but it's also more than.
Periodically, just dealing with a bit of a chest cold. I'd just like to pick up on Bonnie's comments as pertaining to Indigenous involvement, and I'll speak to it a bit more concretely later. But I think it's important for a couple of reasons. One is the recognition today that our First Nation governments are recognized within the system. They're consulted on a number of things. It's just the right thing to do. On a very pragmatic level, in terms of dealing with conflict at public order events, I think there's also a perspective that's brought from Indigenous communities and Indigenous leaders in terms of ways and means regarding, excuse me, the resolution of conflict. That I think it's an important perspective that can be brought to bear. And as I'll speak later, the involvement of Indigenous leadership from the planning through to implementation, development of strategies, tactics and operations, and the implementation thereof. I think it's an important perspective that is for both those reasons very important. Thank you.
Excellent. Thank you. When and where, and on the one hand, and maybe also a set of thresholds that would determine, when this agency would step in or not. Who do you envision deciding whether those thresholds are met? And what I have in mind is what would guarantee or what would suggest that in the future we wouldn't have the kind of confusion we've seen in these earlier events arise in the event of a dispute over whether the threshold was met?
So,
Cal Corley, please.
yes, thank you. So, Robert, just to begin, one of the most difficult matters when we were doing these exercises back when was in that transfer, for example, under the Security Offences Act. That's one of the most difficult and awkward things because, and from an RCMP perspective, assuming those responsibilities, we always felt it important as a matter of practice that you continue to keep the local police actively engaged and involved. But the locus of accountability and responsibility shifted, and you tried to keep it workable like that. In terms of when I spoke about the thresholds, and I'm thinking, as I say, specifically about an absolutely out of control situation where we're just short of, for example, calling in the military, that everything else has been exhausted. But on the other hand, you've got the Security Offences Act, National Security.
Folks, if you want to be kept up to date on what's happening at the Emergency Act inquiry, including my live tweets and some clips and highlights that occurring at the Emergency Act inquiry, by heading over to revolutionnews.ca/Emergency Act Commission. That's revolutionnews.ca/Emergency Act Commission. And of course, here, folks, while you're there, please head over to donorbox.org/Emergency Act Commission. That's donorbox.org/Emergency Act Commission. And of course, here, folks, if you could chip in a buck or two, that will be greatly appreciated, as it will help me cover my travel expenses, including my expenses on food, as bringing you these stories doesn't come for free. Thank you so much.